So Bostic, they said we're going to reset Wimbush so that, well, you heard Kennebrew, right?
She said she wanted to stay.
Well, she's up there at Cobb, so I'm gonna let her go ahead and go in. So I just need Lindsay.
Okay.
All right, let's see. How about we'll take Timothy Haynes. Is Miss Browning here yet? Miss Browning's not here yet. What about Miss Gerber? We'll take this until Miss Browning gets here. All right, so
Your
we'll take.
Honor, Miss Browning is on
I'm
the,
covering for Miss Browning, Your Honor.
okay.
But we can definitely go ahead and take Miss Gerber's case first while I prepare.
Okay. All right. So wave your hand when I call your name. Is it Antron Lindsay? Or just nod your head. There you go. Okay, thank you. All right, it's position 3, Bostic, 24 PI 004807, 96 days without indictment. There is a $36,000 good bond as of July 6th for cruelty in the second, simple battery, family violence, disorderly conduct, and cruelty in the third. Pre-trial. Unless something's been dismissed or something at a prelim, Ms. Gerber, let me know. Pre-trial.
Which defendant?
Lindsay, oh, Antron Lindsay, sorry. Number 3.
Lindsay Anton. 17 cycles hold for probation violation 4/17/24, ag assault in 2017, DUI in 23, FTA in 2017 and 19. Nothing further.
All right. Go ahead, Ms. Gerber.
Yes, Your Honor, Mr. Lindsay is going on 36 years old. When I was able to meet with him up in Cobb County, he and I spoke about him being in this position in life where he knows he's got some cycles, but at going on 36, he is ready to work on really trying to not be labeled by that past and going forward from that. Before his most recent arrest, he was actually working at the Dollar General warehouse down in Noonan, and I believe his hold is for Noonan at the moment. But they have an $18 an hour rate that he could go back to if released. And so we are requesting that he'd be allowed to return to that work. He has an address in Coweta County, where he would be living at his sister's house, and so he would be able to abide by any stay away. Unfortunately, the amount that the bond has been at for the last few weeks is just outside of his or his family's ability to pay. So we would ask the court to consider a $15,000 bond. He is the father of 6 children that he would like to provide for, and he did share with me that the issues in this case and a lot of the cycles that Your Honor may see is that he does drink. That's his one vice, and that sometimes that does get the better of him, but that can be, Your Honor, controlled with any type of, no drinking requirement on a bond, Your Honor. And so we would ask that you lower the bond so that he can await the indictment from the state on the outside and contribute to his children's life in a more meaningful way.
Miss Dorsey Jones, have you spoke with the victim?
Your Honor, the person that answered, they said that they would ask that bond be denied.
All right. Go ahead, Mr. White.
Judge, this defendant has a previous felony conviction from 2016 for an aggravated assault with family violence. And I'm just trying to see if it's the same victims, but I don't have. No, it's not. It's a different victim. The previous victim was Miss Bianca Campbell. It appears that this victim is Miss Amanda Davis. Your Honor, having a previous family violence, now we're here on a second family violence. Also the fact that he has 17 cycles, and the previous family violence was from 2016, less than 10 years ago. Judge, this is not a good candidate for bond, certainly not a good candidate for any reduction in bond from a very reasonable bond that's currently set at $36,000. Now that he has a bond, there is no presumption of any prejudice. No presumption will attach for at least another 9 months. And the state, in fact, now has another 3 years and 9 months to indict this case before there is really any legal prejudice at all to this defendant. There is no basis in either law or fact for this defendant's bond to be reconsidered. The state does object to any change in the bond at this time.
All right.
And
So
Your Honor,
Okay.
I neglected to ask if Ms. Jones knew who it was that answered the line, because I do believe that is a change in position for the victims compared to the notes I have from Mr. Rogalski regarding the first.
She didn't. She just told me she was a family member and that they did not want him to get out. I didn't speak directly to the victim. She just said that she was a
Okay.
family member.
Okay.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Sir, you're going to stay out of Fulton County unless you're here for court or to see your lawyer. That's the only reason you come to Fulton County. As soon as you get out, you get in your car and you drive down there. No further contact with Amanda Dennis. Stay away from 942 Hank Aaron Drive in Atlanta, Georgia, which should be fine because you're just going to stay out of Fulton County. Let's see. You have a 24-hour curfew, court, lawyer, medical, employment. You have to supply the name of your employer, proof of employment schedule, and the exact location you'll be working. So I got 19,000, 9,500, and 3,000. 19,000, 9,500, and 3,000. Best of luck to you, sir. You can leave the booth. Timothy Haynes. All right. We got position 5, Timothy Haynes, 24 PI 001921. 204 days without indictment. I've got, was a $4,000 good bond. I think we brought this back because he'd been accepted
That's correct, Your Honor.
into Hope House. So he's got debt by taking, financial transaction card fraud, and financial transaction card fraud. Wow.
In regards to Haynes, 32 cycles, FTAs, forgery in the first, 10 counts. That's old. 1, 2, 3, 4. Felonies more than 10 years old. 2016 burglary, 2016 financial transaction card theft in 2016, and 2019 couple of probation violations. 2022 CP 214966 financial transaction, 3 counts, nothing further.
All right. Go ahead, Miss Beck.
Thank you, Your Honor. Mr. Haynes has been in for over 200 days. As you said, 204 days. He is 53 years old. He has lived in Atlanta for the last 20 years. He is a high school graduate. Prior to his arrest 204 days ago, he was living in the Atlanta Recovery Center. However, as you mentioned, he has been accepted into the Hope House program. So now that he has a place to go, these are all non-violent crimes. We would be asking for a bond not to exceed $2,000 so we can utilize the bail project to try and get him out so that he can go into this program.
All right. Go ahead, Mr. White.
The state will note that this defendant also has an indicted case 24SC 002172. And just trying to see if this has been and this was transferred to Judge McBurney because this defendant is a C recidivist and has more than 5 lifetime felony convictions. Judge, he's got I understand that, you know, the Hope House, but this defendant is just not a good candidate for bond, probably not a good candidate for the Hope House, given the fact that he committed the current offense while he was on bond for a previous offense that was financial transaction card theft. 3 counts, financial transaction card fraud, 1 count, possession of tools for a crime, and criminal trespass. He also has pending an unaccused misdemeanor financial transaction card fraud case, 24 PI 001949. Judge, I understand 204 days. However, this defendant does have a bond. The state has roughly 4 months to indict it before there's any presumption of prejudice at all. Has 3 years and 4 months before there's any prejudice and legal prejudice to this defendant for this, given the fact that he does have the indicted case, given the fact that there is no possibility of legal prejudice and there is no basis in either fact or law to disturb his bond at this time. The state is opposed to any change in the bond. No further.
Your Honor, if I may.
Of course, Ms. Beck.
Thank you so much. I'm so glad that the state brought up any presumptions because he does have the presumption of innocence. Unfortunately, he's been sitting in there for 204 days with that presumption of innocence, and the state has chosen not to do anything about that. They have chosen not to indict his case in the last 204 days. So I would ask Your Honor to set a reasonable bond because the state has chosen not to do anything about the bond or his case for 204 days. He has celebrated a birthday while he's been in there. There's been major life milestones for 204 days that he has missed out. And he's obviously a great candidate for Hope House because he was accepted. They believe in mercy. They believe that people can change. So that's why he was accepted there. So we would ask for a bond that he can actually get out and try and change his life.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 6615 Roswell Road and 7525 Roswell Road. Must supply an address where you'll be living. If something falls through with Hope House, or once you move from Hope House, sir, you need to make sure you supply an address where you're living. No further contact with Blake Howell, Howe, and Blake Garrett, Garrett. I'll give you 250, 1,000, and 1,000. Best of luck to you, sir. You can leave the booth. Cobb, you can leave too. All right. Benjamin Cox. Raise your hand, Benjamin Cox.
Judge, I do have a question about Lindsay's charges. I think he only had 3 charges and you gave 4.
Okay, because I said, okay. Wait a minute. Which one was the disorderly? Which one was dismissed? Cruelty in the third?
Yes, the last one.
Okay, well then just scratch that off.
I'm sorry, Your Honor, that was my mistake.
No, mine too. The bond order just was different from my calendar. Sorry about that. Benjamin Cox. Who's Benjamin Cox? Wave your hand if you're Benjamin Cox, gentlemen. Don't see anybody waving the hand. Do you see him?
Judge, I apologize. Judge, he's in North 206.
So I got, Mr. Cox, can you hear me? Wave your hand.
Mr. Cox, there he is.
There we go. Okay. All right, it's number 2, 24 PI 004836. 94 days without indictment. $30,000 good bond is July 30th on arson in the first degree, criminal damage to property in the first degree.
In regards to Mr. Cox, 26 cycles, a simple assault under obstruction and misdemeanor in 2019, FTA and 21, history of criminal trespass, no prior felony convictions for his GCIC. Nothing further.
All right, go ahead, Mr. Dobbs.
Thank you, Judge. Mr. Cox has been in jail for 93 days. He has lived in the metro Atlanta area for about 5 years. Much of his extended family lives here in the way of aunts, uncles, and cousins. He is physically disabled and therefore is very limited in what work he can do. He did glass installation for as long as he could, but now only gets SSDI income, which he does not currently have access to. Judge, the only route that we have to secure Mr. Cox's release pre-indictment would be to get bail assistance. he was not homeless at the time of these allegations. However, because of these allegations, he has since become homeless. I have, of course, made a social work order request in an attempt to try to get Mr. Cox in another rooming house situation, which is where he was residing at the time that he was picked up on this case. As your honor is well aware, no bail assistance or organization will pay that bond for Mr. Cox until we have a verifiable address where he can live. In the way of criminal history, Judge, this is his first arrest since 2021. He is not a convicted felon, and there was only one FTA through several cycles, and none of his past criminal history resembles what he is accused of in this case in any way. We understand this is not a evidentiary hearing, but from the warrant itself and what what the state is alleging against Mr. Cox, the reason he's accused of this arson is because someone in the house saw him in a argument a bit before. Again, this is not a evidentiary hearing, but we did want to put that forth for the court's consideration in setting bond as it goes to the element of danger. Judge, for all of those reasons, we are asking for Mr. Cox's bond to be reduced today from $30,000 aggregate to $10,000, $5,000 per count. Thank you.
Any victim contact?
Your Honor, a text message and an email was sent to the victim, but no response.
All right, go ahead, Mr. White.
Judge, the fire was actually apparently Mr. Cox's room in the rooming house that he was a resident at. I'm sure your honors reviewed the warrants and seen that this is in fact the allegation that they set the rooming house he was at on fire. Judge, this is another one where this defendant for first degree arson, $30,000 is an extremely reasonable bond. Whether or not this defendant has a history of this type of behavior or not. He's only been in for 93 days. He does have a bond. He received that bond on July the 30th, which is only 68 days ago. Not sure why we're revisiting it so early, especially because the state has 9 months before any possibility of prejudice attaches, has 3 years and 9 months before any legal prejudice attaches. And just to point out, Judge, the presumption of innocence is the only reason that defendants are entitled to a bond. Once the presumption disappears, there is no more possibility for bond under any circumstances. And the law in this state, as codified in 17-6-1E, is that a defendant has to meet 4 factors in order to be eligible for a bond. Those 4 factors also govern the amount of the bond and the conditions of the bond. Your Honor, there is no basis in law or fact and no attachment of any presumption of innocence, despite what my learned colleague would have the court believe. That just simply doesn't apply here. Judge, there's no reason to disturb this bond. 30,000 is certainly more than reasonable, and the state is opposed to any change in the bond at this time. Nothing further.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 950 Joseph E. Boone Boulevard, Northwest in Atlanta, Georgia. No further contact with JIMOH Campbell, CAMPBELL, last name ALIYA. You'll have a 24-hour curfew, court, lawyer, medical. Also, must supply an address where you'll be living upon release. So I'll do 23,000 and 3,000. Best of luck to you, sir. You can leave the booth. Let's see. Jesse Callaway. Wave your hand if you're Jesse Callaway. All right. All right, Ms. Gerber, it's position 8, Bostic 24, PI 004747, 98 days without indictment. Got a $50,000 good bond as of August 19th on, wait a minute now, something else may have been. So is the only, Ms. Gerber, is the only thing pending here possession of a firearm?
No, I believe there is still the robbery that's pending.
All right, the armory robbery or armed robbery?
Hmm,
I think
let
it's,
me double check my paperwork.
looks
I
like it
believe
may
it's
be.
an armed robbery.
All right, possession of a firearm during the commission of a felony and armed robbery, $50,000 good bond, 98 days without indictment. Free. Ah. Number 8, Bostic.
Callaway, 23 cycles, marijuana with intent, marijuana misdemeanor in 2015, disorderly conduct, given false name in 2010. Other felonies are open case for terroristic threats and acts, 24 PI 002919, theft by taking, theft of service, 23 CP 223263. Nothing further.
All right, go ahead, Ms. Gerber.
Yes, Your Honor, and I am just looking up his jailing because the initial booking was on robbery and not armed robbery. And I'm looking to see what the
Robbery as well.
I don't
Look
want
like
to.
they,
Doing robbery, Judge.
so they dismissed robbery and replaced it with armed robbery?
No, I'm just showing him, hang on.
Wait a minute. Hold on.
I'm just showing an order of dismissal on the robbery, and it looks like the only thing that's left is the firearm. That's bizarre.
August 19th, there was also an armed robbery on here on the bond order. If you look at it.
The robbery was dismissed and it looked like they changed it to armed robbery at some point.
All right, yeah, so it's just not showing in the jail screen.
That's where I see it is on the jailing.
Judge,
Talk about on Odyssey. Yeah, it looks like, so when you, on the 19th, the order of commitment Superior Court added armed robbery, dismissed robbery.
all right, I see.
Yeah, so it's a $50,000 bond.
And so, Your Honor, I understand that, having bond on an armed robbery, while we do appreciate that, the basis for our request here and the request in the reduction is based on Mr. Callaway's ability to pay, which of course is a consideration that, the court takes into account, under the statute that, the amount necessary
Hold
to
on, Ms. Gerber. Hold on, Ms. Gerber. 5 North, booth 3. Stop. Not a salon. Pay attention. Focus. Go ahead, Ms. Gerber.
Thank you, Your Honor. So Mr. Callaway does actually have a property that his wife has tried to use here in Fulton County to bond him out. Just an old piece of land. And unfortunately, although they've been legally married and living here, and I believe they've been legally married for about 35 years, the property is in his name alone, and he can't be the guarantor for himself in signing that paperwork. And so unfortunately, he's found himself in a bit of a bind where he thought initially that he'd be able to make this amount. He is not able to. He's 57 years old, and he's actually lived at 2369 Jackson Drive in East Point for over 10 years. He has a limited history and is eager. This is a situation where I believe the folks involved know each other. This is not a strangers interacting type of situation, and is eager to represent, be present at every court date so that the truth comes forward ultimately. And so we believe he is a great candidate, not only for a reduced bond because of his eagerness to return and present his defense. He has significant ties to the community. That $50,000 amount is outside of what his means are able to cover. So we would ask for a reduction in half down to 25, if Your Honor would consider it, 25 total.
Any victim contact, Ms. Dorsey Jones?
Yeah, Your Honor, there were 2 text message and 1 voicemail left.
Okay, no response.
No, ma'am.
All right, go ahead, Mr. White.
Judge, as the court is aware from the warrants, this is an armed robbery of basically a convenience store using an AK-47 as the weapon of choice.
And Your Honor, the warrants do indicate that although it looked like an AK-47, it was a BB gun, which is why Mr. Callaway is eager to return to court and contest some of these facts that we're looking at.
All right, go ahead, Mr. White.
Judge, bond was last addressed and set on August the 19th. What is that? 40 days ago? On an armed robbery. That there is no reason to be addressing bonds, especially not on serious violent offenses, every 40 days. It's frankly an abuse of the court system, and it's a drain on resources that could be much better used elsewhere. Judge, this is one where this defendant, the original arrest, he was actually on bond for a theft by taking at the time of the original arrest. This isn't someone with a limited record as was portrayed, but rather this is a career criminal who's while he's on bond for a theft by taking, commits another theft related offense. There's just no reason for us to be here on this. The state is opposed to any reduction in the bond. $45,000 bond that was set on August the 19th is certainly charitable for an armed robbery. And the state is opposed to anything to disturb it, nothing further.
Mr. Galloway, I would venture to guess Ms. Gerber doesn't want you to say a word, and you're on mute. So, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3094 Washington Road in East Point. Also, when you get out, you have a 24-hour curfew. Court, lawyer, and medical. That's the only reason you leave your home, sir. Court, lawyer, and medical. No further contact with M as in Mary, D as in David, last name U-D-D-E-N. M-D, last name U-D-D-E-N. All right. So we got 4,000 and 44,000. Best of luck to you, sir. You could leave the booth. Corey Jones. Wave your hand if you're Corey Jones. There we go. All right. So position 1, Bostic, 24 PI 004849. 93 days without indictment. There's a $6,000 good bond as of July 30th. I got Earning Auto with intent to commit a theft or a felony and willful obstruction. Wow.
In regards to Jones, multi-state offender, 23 cycles in Kentucky at FTA, history of criminal trespass, 3 in Arizona, 1 in Texas, 5 in California, threatened school public officer in 04, 34 in Georgia, FTA, history of criminal trespass, open criminal trespass, 23 CR 0059 23G, open case in DeKalb for public PI, first or second. Nothing further.
All right. Any victim contact?
Yeah, Honor, there was a message left for Daniel SCHEMESQE, I think it is. But when I called, they stated that they would call me back, and I didn't get a call back. So I did send a text explaining the nature of the call.
All right. Go ahead, Mr. Dobbs.
Thank you, Judge. Mr. Jones is 47 years old. He has lived in the metro at Atlanta area for the past several years. Judge, Mr. Jones is homeless. We've made a social work order request for both MH treatment and a placement, and our plan is to get bail assistance once we have that. So I ideally, if we're able to, before the state moves the case forward, we can get him a placement and treatment, and then secure his release through the bail project. Judge, his criminal history is almost entirely nonviolent, if not totally non-violent. These are nonviolent charges here. Today, he has been in for 93 days to this point, and has not been able to make the current bond. He's not going to be able to make any bond, which is why I've mentioned all these things about the bail project and whatnot. And that is, of course, a factor to be considered by the court in setting bond. For those reasons, Judge, I am asking for $3,000 on the entering auto and $500 on the willful obstruction misdemeanor, for a total of $3,500. Thank you.
All right, go ahead, Mr. White.
Yeah, this defendant has managed to pick up 40 cycles in 5 states in the 29 years that he has been an adult. And he's only been in, I mean, this
93 days.
yeah, but his bond has only been set for
in July.
68. And so here it is, we are 67 days since his last bond was set, reconsidering a bond where there is no possibility of any presumption of prejudice for at least 9 months. There is no prejudice for at least 3 years and 9 months. There is no basis for reconsidering this. There is no reason to reconsider the bond, especially given the fact that we're dealing with a career criminal who is likely to pick up a 6th state in his nationwide crime wave when he's eventually released from confinement. This isn't a question as to if he'll reoffend. It's a question as to when and where he will reoffend when he's eventually released from confinement. Judge, $6,000 bond in this case is nominal, charitable, dangerously low. The state would recommend on the entering auto a bond of not less than $50,000, and on the misdemeanor obstruction a bond of not less than $5,000, or a total bond of $55,000. That would certainly be more appropriate and actually be a much more reasonable bond, which would better suit all of the reasons for bond than a $6,000 nominal bond that is being reconsidered every 60 days. Nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Must supply an address where you'll be living upon release. No further contact with Daniel Schmeiser, Schmeiser. Stay away from 4375 Fulton Industrial Boulevard. Cannot go back there. $4,500, $4,500, $4,500 good bond. Best of luck to you, sir. You can lead the booth.
Thank you, Judge. My third case on tonight's docket was indicted. May I please be excused?
Yes, sir. Have a good evening.
Thank you. You as well.
All right, Johnny Mattis. Wave your hand if you're Johnny Mattis. You can lead the booth, sir. Johnny Mattis, wave your hand so I can see you. Wave your hand. I cannot see anybody wave their hand. Johnny Mattis, raise your hand up. There we go. Position 9, 24 PI 005168, 97 days without indictment, $15,000 good bond on aggravated assault. Wow.
In regards to Mr. Mathis, 1 arrest in Michigan, dismissed, 30 in Georgia. All his convictions are old. Most recent, I believe, was in the 90s for theft by receiving and burglary. He's in custody on a misdemeanor FP8. I think that also was dismissed. He got time served on the criminal trespass. Nothing further.
All right. Any victim contact?
A victim was contacted by the name of Torres, Horsico. It was 2 attempts via phone call and 1 text message.
Okay. Go ahead, Ms. Murray.
Thank you, Your Honor. I was actually hoping to request, and I just wanted to make sure that Mr. Mathis heard this. I was actually hoping to request that we reset this case for 2 weeks. The reason being is that my social worker has been working on getting Mr. Mathis into a program, and Better Way Ministry should be out to interview him soon. I just want to give him the best chance at getting his bond reduced to an amount that perhaps could be posted through the bail project. And so we would ask for it to be maybe pushed out to what is the 22nd, so that there's time for Better Way Ministries to interview him and to get the best reduction possible.
All right, you got that, Mr. Dukes?
Yes, Judge, I got that.
All right, see you back in 2 weeks, sir. You can leave the booth.
Okay, thank you.
I got position 4, Isaiah Madison. It's 4, 5, and 6. Mr. Madison, there we go. All right, position 4, 24 PI 004 809, 95 days without indictment. No bond as of July the 6th on hijacking motor vehicle in first degree, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Number 5, 24 PI 004 810, 95 days without indictment. No bond as of July the 6th on armed robbery. And position 6 is 24 PI 004 811, 95 days without indictment. No bond on terroristic threats and acts. Trial.
Second Madison, Isaiah, 11 cycles. On probation for aggravated assault with deadly weapon, 4 counts. With intent to rob, 19 SC 171485, 19 SC 171639, 19 SC 171733, all sentenced same day, 11/16/22 for 16 years. And then in Cobb for theft by receiving. Did we do 8 and 9? And then there's open 24 PI 00635 armed robbery, hijacking, aggravated assault, firearm during. And then I already said that. Nothing further.
All right. Any victim contact, Ms. Dorsey Jones?
Yes, Your Honor, I did speak with someone and they said they do not want to discuss the case. They would prefer if the judge took care of the matter.
Okay, we'll do that. Ms. Gerber?
Yes, Your Honor, the basis for our request today is that it has been no bond for 90 days without an indictment. So we do believe that Mr. Madison is entitled to bond on, by my count, it's the 5 charges that are before Your Honor. He will be living at the family home, his uncle's place, at 1004 Catherwood Drive, 30310, and believes that he can get work at the Duracell warehouse. That's where he was working most recently. He is forklift certified and so can maintain gainful employment. He received his GED in 2017 and has also had experience working at Wendy's in and around the Atlanta area. And so we would request that he be allowed to stay within Fulton County because that Catherwood Drive, based on my understanding, is in the Fulton County area. He's 25 years old, but has quite a few kids that he would be taking care of and providing for if released. And although he has these new charges, my understanding is that he has been in touch with probation, was communicative when he was on the outside, and so I do believe that he will be able to comply with any of the conditions that Your Honor might impose on a bond. That said, he has been in custody more than 90 days and he does not have great means, and so we're asking for as low as Your Honor can go for bond in this matter so that he can hopefully work on fighting these cases from the outside of custody. And that is our presentation. I do understand there's probation matters that he will have to handle, or he did that this morning, I think. So probation is handled this morning, and then eventually there will be, I'm sure on the 6635 case, more hearings, but we'd ask Your Honor to set a low bond.
All right. Did they revoke his probation?
I am not sure, Mr. Madison.
Oh, well, he's on mute, so you didn't handle that, right?
I did not, Your Honor.
All right, go ahead, Mr. White.
It's absolutely inexcusable that our office failed to indict these within 90 days. Especially given the fact that this defendant has a September 11th, 2024 arrest for armed robbery, hijacking a motor vehicle, aggravated assault, and possession of a firearm during the commission of a felony, which are, well, identical to what he's in for here, and very, very similar to what he's currently on probation for from 2019 and for his previous 2017 conviction of almost identical conduct. Judge, it's frankly inexcusable and frankly inexplicable as to how we did not get this indictment. State would request that any bond that the court is inclined to set include a strict 24-hour curfew, only exceptions being medical emergencies when taken from his house in an ambulance and in-person court appearances. State would request that curfew be enforced by an ankle monitor. Nothing further.
All right, on position 4, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1500 Riverwood Lane in Roswell, Georgia. No further contact with Frederick Jackson. If the funds are available, you're going to have a 24-hour curfew with the ankle monitor paid for by the county. The only reason you leave your house is court, meet with your lawyer, or medical procedure. So I do 75,000, 20,000, and 20,000. Position 5, ending in 4810. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 895 Holcomb Bridge Road in Roswell, Georgia. No further contact with Raymond Madden, Madden. That ankle monitor be provided by the county if there's funds with a 24-hour curfew, court, lawyer, medical. That's the only reason you leave your house, sir. $40,000 good bond. On position 6, ending in 811. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 261 Grove Place in Roswell, Georgia. No further contact with, what in the world did I just write down here? Andrew Wellington, Wellington. If available, you have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical is the only reason you leave your house, sir. $25,000 good bond. Best of luck to you, sir. You can leave the booth. Thank you, Ms. Gerber.
Thank you, Judge.
All right. I guess you're Mr. Sutton. You can leave the booth, sir. All right. So I got position 12. Let's see. It's 24 PI 004 772, 98 days without indictment. We got a $85,000 good bond. I've got, let's see. Manufacture, distribution, possession with intent to distribute substance in Schedule 1 or 2. Purchase, possession, manufacture, distribution, sale of marijuana. Manufacture, deliver, distribute, controlled substance in Schedule 1 or 2. What I wrote down is 408 grams of marijuana and 1,018 MDA pills, allegedly. Pre-trial.
Sutton.
She's taking
Maryland,
the
2
view back.
cycles, deadly weapon, concealed misdemeanor. Georgia, 11 cycles, purchase, possession. And 02, fugitive from justice, prior arrest, open case 23 SC 187-109. Ag assault, 2 counts. Ag assault with intent, capital, firearm during firearm by a convicted felon. Last arrest was in 2020. Nothing further.
All right, go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Sutton is 41 years old. We do have a good address for him. It is the address that is on file. He will be living there with some family members. He has lived in Atlanta since 2000. He does have most of his family that lives here in the state. He got his GED back in 2002. Prior to his arrest, he was working at the banks on Bankhead. It's an event space. He was working there as a bodyguard, and he had that job for 2 years. He recently had 2 deaths in his family. He is anxious to get back home so that he can adequately mourn their losses. We would be asking for a bond not to exceed $50,000, Your Honor.
All right, go ahead, Mr. White.
This defendant has, as was noted, a pending ag assault 23 SC 187-109. with a looks like $160,000 bond that I don't see that this defendant has made. And then he has this new case. I guess he did make it because he picked up this new case. For trafficking in level 3 trafficking in multiple substances. The bond is certainly more than reasonable. It was set. Judge, this is last order for bond was July the 30th.
Yes.
We're 68 days out. And it's only a $95,000 bond on an offense that the conviction carries a $500,000 fine that's mandatory. That just hurts my head to even think about what possible logic there was. I'm sorry, $85,000 bond to setting such a low bond, given the sentence in this case. Certainly a bond that would be at least the minimum fine required by law would be more appropriate. And on what basis is there to reconsider the bond in this case, especially given the fact that we're only 68 days since the last bond, that he does have a bond, that he's on bond for another offense pending before Judge Dunaway's division. Your Honor, there is no basis for disturbing this bond at all. If there's anything that needs to be done with this bond, it needs to be raised from $85,000 to $500,000. So it is the state's request that this bond be raised to $500,000 to more accurately reflect the charges that this defendant is facing. And also, just because that much better would fit the statutory requirements for bond and the statutory mandates. 68 days. I really can't fathom why we're here only 68 days after the bond was set. Nothing.
Your Honor, if I may be able to clear that up a little bit. It's actually not a statute that requires them to be heard every 90 days. In fact, other counties in Georgia hear clients every like 2 to 3 weeks until they're indicted. It's a Fulton County oddity that we wait every 90 days. I think that was based on ORCA, like, you know, all the backlogs, so they had to wait every 90 days. So within 68 days is not outside of any statute or anything wild. Just because he was heard 68 days ago does not mean that it cannot be changed. Actually, I feel because it was scheduled for this calendar, that means that it can. And you absolutely have that ability to change the bond. And regarding the $500,000 request, that fine that's mandatory is only if he is found guilty. Unfortunately, he's not going to be able to be found guilty until he's indicted, and he does have that presumption of innocence. So until he is indicted, if he is found guilty of that trafficking charge, then that would be when we can get into that $500,000. Until then, because he has that presumption of innocence, that's not even a question. So we would be asking for a reasonable bond because he has just been sitting in there for around 90 days in total. So that would still be our request.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3749 Campbellton Road in Atlanta, Georgia. Let's see. You have a 24-hour curfew, court, lawyer, medical. You said he's got a job?
Yes, Your Honor.
All right. Employment, we have to supply the name of your employer, proof of employment schedule, and the exact location you'll be working. All right. So I got 12,000, 49,000, and 18,000. Best of luck to you, sir. Thank you. Right, so it looks like that is it. Hopefully, if any of you folks have anybody that's in Florida, really South Georgia, they stay safe during this hurricane.
Thank you, Your Honor. May I be excused?
Thank you. Oh, Miss Beck, on the other case, make sure that Miss Browning submits a order for a 30-day supply of medication.
Okay.
Down on my notes.
Thank you, Judge Manny.
All right.
She's out for like 2 weeks, but I will send that note to her. But that's why there may be the delay.
All right, sounds good.
All right, thank you, Your Honor.
Okay. Yes, ma'am.
I'm Viola Morrell from Court Watch. I don't have any information on position number 11, Stephen Daigle. Can you help me with that? I must have just missed it.
It was indicted.
Daigle was indicted. 'Cause that was Browning's as well.
Daigle was indicted, and where's that?
Okay. Thank
Daigle
you.
and Sterling Hood.
Equals indictment number 24 SC 004875.
And also, wait, let me see. And also Hood was indicted. Sterling Hood.
Hood, indictment 24 SC 004781 signed to Cox.
Okay. Thank you so much, guys.
Thank you, Your Honor.
All right.